Good morning. I'll call to order docket number 42509, Georgia Power Company, petitioner versus Walton Electric Membership Corporation, respondent and stipulated and very active intervener, Nestle Purina Pet Care. May I have appearances, please?
Good morning, Ms. Gibson. William Droz with Troutman Sanders on behalf of the Georgia Power Company. With me at council table is Bob Edwards, Ashley Cameron, and our client representative, Glenn Dyke.
Good morning. I'm David Cook, and I represent Walton EMC. With me on behalf of Walton is Antonio Veal, and we have several representatives, including the CEO, President and CEO Ronnie Lee, behind me. Thank you.
Good morning, Your Honor. Curtis Romig here on behalf of Nestle Purina Pet Care Company. I have with me my colleague Nick Vito and the client representatives Josh Roche and David Narkowitz. Thank you.
Thank you. Well, as we just discussed off the record, we'll begin with motions. And I think that's Walton EMC.
Thank you. Good morning. I'm not going to belabor the point. I know you had the opportunity to look at the motion that is written. The motion on behalf of Walton EMC, and that was also joined by Nestle Purina, essentially states that expert testimony that is being submitted before this hearing body by Georgia Power is improper. And specifically, we're talking about the expert testimony, or the expert opinions, I should say, relating to certain definitions of certain terms that are relevant to the Territorial Act. We're also talking about how some folks, or some of the witnesses at Georgia Power, are trying to opine about how certain actions taken by Nestle Purina and Walton EMC do not meet certain definitions or certain standards of these particular terms. For example, destroying, dismantle, and reconstructing substantial kind. Those types of statements are for you to determine. And in this type of situation, it is improper for any other witness to opine on whether those elements have been met. Of course, can a witness submit factual testimony? Yes, they can. Can a witness say X, Y, Z happened? Yes. But to take the next step to say X, Y, Z does not fit into destroying, dismantle is a bridge too far. And that's what I would submit to Your Honor today. And if you look at the test, you look at the rules of evidence, you look at the cases that were cited in the brief, you look at some prior PSC cases, and that has been the consistent holding and the consistent rule. In this specific case, if you look to the Habersham case, Georgia Power versus Habersham Electric Membership Corporation, docket number 237H1U, it specifically talked about expert testimony and what is allowable. For example, in Habersham, the hearing body noted, the purpose of Mr. Blaine's testimony was to offer an expert opinion on the meaning of certain terms of the Territorial Act, and to apply such statutory terms to the premises which he had inspected in person and by photographs. The hearing body went on to say that that was improper testimony, it was improper expert testimony, and that it should not be allowed. Now, if you compare that to the witnesses that Georgia Power have submitted, it is a very analogous case, and because it is an analogous case, it should be an analogous ruling, and you should exclude that type of testimony. For example, in Georgia Power's testimony, there are witnesses who they presume to lay the foundation for to be experts and to opine in a certain way. They state that certain premises are not new. For example, I know new by itself is a term that's easily defined by the dictionary, but new in the sense of a new premises in this particular setting means something much different. The new, again, goes into whether a particular premises was destroyed or dismantled and reconstructed in substantial kind. And then, if it's not in substantial kind, in this particular situation, it can be deemed a new premises. So to make the step to say this is not a new premises, that's making a legal determination that Your Honor is going to make in this case, and that should not be allowed as far as expert testimony or given the weight of expert testimony. The premises has not been destroyed, demolished, or dismantled. Of course, any word that we have in the code, any word that we have, in any rule, if you take that word out, you can look it up in a dictionary and it'll give you a meaning. But in this particular setting, premises have not been destroyed, demolished, or dismantled. That destroy and dismantle has a special meaning in Territorial Act cases. And in that situation, they're making that determination again that you are supposed to make. And if you are supposed to make it, you don't need an expert to tell you how to make it. And that is also that's told over and over again by the Court of Appeals, by various appellate courts, and by the rules of evidence. And I would point to this is very specific and very telling. I would submit to the hearing body. Mr. Dyke's testimony says specifically, my testimony shows, therefore, that Walton Electric Membership Corporation's decision to extend services to this premises as reflected by notice provided on April 10th, 2019 was to an existing, therefore not new premises lawfully served by Georgia Power. Again, that not new, that's the testimony we're talking about. You don't have to ask the question, what's the meaning of this word for it to be excluded in this circumstance? They are telling you what it is. They are saying they're making the decision for you, and that is improper. That should not be allowed, and that should be stricken from the record. He went on to say, Mr. Dyke, my testimony also shows, contrary to the assertions of Walton EMC and Nestle Purina, that the premises has not been destroyed, demolished, or dismantled. Instead, my testimony and the admissions of Walton EMC and Nestle Purina demonstrate a continuity of the premises that is in substantial kind, and that's in quotation marks even within his testimony, to that served by Georgia Power for the past 28 years. Indeed, it has always been a manufacturing and warehouse premises with support functions and infrastructure. That's Mr. Dyke's testimony, page 2, 19 through 31, and also page 3, 1 through 6. That type of testimony is what we're talking about. That was also done in some instances by Buddy Lawson, who was also one of their witnesses in his written testimony and also in his written expert report. Now, getting back to the specific case law that we're talking about, if you look to Clayton County v. Seagrass, 333, Georgia Appeals 85, it's a 2015 case that essentially talks about this. It talks about what is needed for an expert to give an expert opinion. The expert has to have some sort of expertise relating to the opinion he or she is trying to give. And in this situation, the expert opinions that are being offered by Georgia Power are opinions of how do we apply this law to these facts. You don't need an expert to do that. This is what you do. This is your job. You do it every day. You do it quite often. Other hearing officers do it. You don't need an expert to tell you how to do that. A layperson can do that. A layperson can say, these are the facts. This is the law. Let's synthesize. Let's see what this says. Let's see what this means. Let's make this decision. You don't need an expert to tell you that. And there's no expertise that you can gather to do that. Can you be a lawyer? Is that what you need to be an expert to tell somebody how to synthesize the law and the facts? And if that's the case, based on the testimony, I've not seen that either of the witnesses are lawyers. They don't work for the PSC. They're not legislatures in this particular situation. They're not any of these things that arguably would give some expertise to essentially tell you how to do your job. And that's not allowed, and it's not proper. So, and you also, even further along than that, if you look to the official code of Georgia, 7-704A, in Clayton County v. Seagrass, they interpreted that statute. And in interpreting that statute, they said an expert may not merely tell the jury what result to reach and may not testify to the legal implications of conduct. That's about as clear as it can get. Of course, in Seagrass, they're talking about a jury. That's the fact finder. In that type of case, you're the fact finder in this case. It's clear. They cannot say, you reached this decision. They cannot say, this conduct by Nestle Purina does not need destroying dismantle. That's not in their purview, that is improper, and the case law is clear. It's a 2015 case. As far as case law goes, I know you understand, 2015 is considered pretty recent, especially under the new evidence code when the rules changed in 2013. So, and I would again point to, I don't want to make sure I put this site on the record. I don't know if I did that earlier. Clayton County v. Seagrass 333, Georgia Appeals 85 to 2015 case. And again, it would be Georgia Power's burden to show that the testimony is relevant, that it meets all the conditions or the preconditions under the rules of evidence. It would also be Georgia Power's burden to show that the testimony and the statements, the opinions, if you will, are reliable in some way. If they cannot point to how was this done, how did you come to this conclusion with some evidence, with some expertise, with some experience that is different from what a layperson has, it's not allowed and it can't be deemed reliable. So there are two fronts where we're objecting to this testimony. A, they can't meet those qualifications to testify about these legal conclusions, to testify about these legal definitions. Could they be experts in something else? Sure. Are they experts in telling you how to be a hearing officer? Absolutely not. So, and even secondarily, assuming they had these qualifications, it is still not allowed under Rule 704. So, again, I'm not going to read my motion to you, but I do want to point out very quickly how the rules of evidence apply to administrative hearings. It's been codified in the rules of evidence as well. If you look at the Official Code of Georgia 24-1-2, the rules of evidence shall apply generally to all non-jury trials and other fact-finding proceedings of any court in this state, subject to the limitations set forth in subsection C and D. Now, if you move down to subsection D4 of the same statute, in administrative hearings, which is where we are, the rules of evidence as applied in the trial of non-jury civil actions shall be followed, subject to special statutory rules or agency rules as authorized by law. So that's where we are. The rules of evidence do apply. It's your determination to make. And I am submitting to you that based on the case law, based on the facts that are before you today, this type of testimony should not be allowed. It should be stricken from the record. It should not be considered. And I can get more specific about some of the terms and the meanings of those terms, but I understand you've done this before, you know these things. And if you have any questions, I can answer those, but I would just save some time for rebuttal to Georgia Power's response.
Okay, and I'd like to tell everyone that I have read all of these.
Good.
Very carefully.
All right, thank you.
Briefly, Your Honor, Walton's counsel did a very good job of explaining the basic issues that have been brought before you in both their motion and our motion, and so I won't spend a lot of time revisiting those. We agree and join the motion filed by Walton EMC with respect to their argument and to the testimony that they've identified. We believe that certain opinions and testimony offered by the witnesses of Georgia Power both invade your province as hearing officer in your decision-making and fact-finding capacity, and they opine upon Georgia law. In addition, to the extent that testimony was proper expert testimony, as Mr. Veal has said, those experts are not qualified with respect to the Georgia Electric Territorial Service Act to render opinions on the terms in that act and the conclusions required by it. Specifically, we've identified the testimony of Mr. Harold D. Lawson, and that testimony is identified both in our motion and in the exhibit to our motion. That's the testimony that we seek to exclude. And if you look at his report that he submitted as an exhibit to the testimony, he states that his purpose of the testimony is to assist in determining whether or not Nestle Purina has destroyed or dismantled the facility. And I think that is key, the facility, not any specific component or system within the facility, but the facility or premises itself, to a degree that would consider the premises a new facility, not an expansion, modification, or reconstruction in substantial kind of the premises. So essentially, Mr. Lawson states that his purpose is to offer an opinion as to the decision you will render in this case, and we think that's improper. And if you look in our motion, we've identified additional specific instances of his testimony, both in his direct testimony and in his exhibit, the report, which is HDL-2. And we think that testimony should be excluded because he improperly defines terms under the Georgia Electric Territorial Service Act. He also invades your province as the fact finder, and we would agree and join with Walton EMC in their citation to the case law. We would also refer you to Georgia Power versus Habersham Electric Membership Corporation, docket number 23781-U. We think that case is very instructive on when such testimony should and should not be allowed, and when the province of the fact finder is invaded by a potential expert opinion. We would also indicate that Mr. Lawson has nowhere in his qualifications, either in his testimony, in the CV he submitted as HDL-1, or in his report, indicated that he is a lawyer or has any experience with the Georgia Electric Territorial Service Act. So even if you were to determine that his testimony is proper as to the opinions he would be rendering, he is not qualified to render those opinions. For those reasons and the reasons that were stated in the Walton EMC's brief, we would request the testimony identified in our brief be excluded. And to clarify the order here, when we just discussed, our assumption was that we would argue as to our motions, Mr. Droz or Mr. Edwards would respond, and then they would continue with their motions, and we would respond at that time. Is that agreeable?
Ms. Gibson, we obviously oppose this motion, both motions, and I should begin by setting the stage. The rules of evidence are developed for a specific purpose. They're the gatekeeper, they're the roadmap with regard to the evidence that's allowed in a particular proceeding. And in considering that, because they are a roadmap, different fact finders deserve different treatment. So where a jury could potentially be misled by certain things, a sophisticated fact finder such as yourself is not. And what has just been argued to you is essentially a jury argument as to why a jury might misunderstand how credible expert testimony could apply to an ultimate issue. And that is where their arguments first falter. 24-7-704A, which is under the new evidence code, which the Court of Appeals and Supreme Court have cautioned need to be followed and not old case law, are very, very clear. 24-7-704A says, because the ultimate issue may be embraced in an opinion does not render it inadmissible. So even if you took everything that they just said to heart, all of it goes to the question of weight. It does not go to the question of admissibility of the evidence. But there are multiple reasons why their motion falters. First of all, it's a DOA under the 704A provision because even if this were ultimate opinion testimony, it's admissible, first. Second, they really have not made a proper Daubert challenge. They have not argued that any of our witnesses are not qualified to offer opinions. So secondarily, they mistake the process by which you would truly argue Daubert motions. And so they've not made a showing that any of our experts are not qualified to offer opinions. Third, even if they did make some showing that they lacked the credentials to offer the opinions that they are, the case law that they cite relates to legal conclusions. You can't embrace the discussion about how the facts apply to the Territorial Act without referring to the Territorial Act. So simply mentioning the various elements that are contained in the Territorial Act and then hanging pieces of opinion evidence on it, which is what our experts have done, is not a violation of any of the case law that they've just cited. And really, in particular instance, they cite to the Habersham case. It's worthy of noting that in Habersham, what they tried to put up was a professor who was an expert investor, developer, builder, and consultant, and he was tendered to provide an expert opinion on the meaning of the terms themselves. And the commission excluded the expert, first finding it's unlikely that Professor Blaine could qualify as an expert under Daubert because none of the subjects he has taught relate specifically to the Territorial Act. Well, unlike that situation, our experts are offering specific opinions about specific facts and the way that they would be applied in the rubric of the Territorial Act. So their own case law doesn't indicate where legal conclusions are being offered. Okay, maybe they have a point, but that's not what our experts are doing. If we were to put them up and simply say, oh, well, this means this, and that means that, that's not what we've done. We've put up their resumes. We've put up their backgrounds. We've provided the factual testimony upon which they relied to form their opinions. We've done everything that even if they filed a proper Daubert motion, that Daubert motion should fail. So we have provided all of the background for the opinions that they're offering, and then you, as the sophisticated fact finder, can determine what weight to give it. But it's not an admissibility question. Lastly, I'll just kind of point out that in looking at this, the 11th Circuit has addressed the 704A question at least twice. We just put those two cases in our brief. But essentially, in both cases, they note generally opinion evidence is not objectionable just because it embraces an ultimate issue. So looking at this in a global fashion, number one, a sophisticated fact finder is different from a jury who could be potentially misled. Number two, there's no proper Daubert motion before you that indicates that the credentials of our experts do not support their ability to offer opinions, distinguish Habersham. Third, they can't offer opinion testimony as to what the evidence means, which is what they've done. And then fourth, there's no basis here to find that they are simply offering legal conclusions. That's not what they're doing. So we would urge you to deny both motions in total. They're not embraced within the scope, the meaning, or the intent of the evidentiary code. And for that reason, we would ask that you deny the motions.
Thank you.
Thank you.
Just a brief rebuttal, if I may.
Excuse me?
Brief rebuttal, if I
Of
may.
course, please.
If I misspoke or if I wasn't clear earlier, I just want to make sure that I was. We are saying, and we have said specifically in our motion, they don't have the qualifications to testify about the definitions of these words, and they don't have the sufficient qualifications to tell you how to apply facts to the law. They don't have that. And specifically in Habersham, if we read the entirety of it, you'll see where it says, while he knows a lot about developing, financing, and managing construction projects, he is not a lawyer. And his opinions on the meaning of the Territorial Act language in OCGA 46-3-8B have certainly not been shown to be scientifically, architecturally, reliable, or valid as required under OCGA 24-9-67.1. Now, you may see or hear that that is a different code than what I cited earlier. But it's important to note that at this time period, under the Georgia Rules of Evidence, they had already adopted the federal rules of evidence as it relates to expert testimony. This rule has essentially been carried over to the 2013 rules. So there is no difference in the application of that law and the application of that rule. And the appellate courts have reasoned that throughout their determinations regarding the new rules of evidence. What I would also point to is that while 704 does say, what opposing counsel says that it says, a Georgia Court of Appeals case, which is controlling precedent, not an 11th Circuit case, which is persuasive, but controlling precedent in 2015 in interpreting that rule said an expert may not merely tell the jury or a fact finder what result to reach and may not testify to the legal implications of conduct. It is not allowed. And as we look at these rules, I do understand that, for example, if you were to rule against us and it ended up going up on appeal, a court could say, hey, she's a sophisticated fact finder, she was able to separate the wheat from the chaff, and that's fine. But I can tell you, and you can look at them yourself, and there was no argument to the contrary, the rules of evidence don't differentiate between a sophisticated fact finder, a jury, or anyone like that. What the rules say is what is allowed. The rules say, and the interpretation by the court say, this type of testimony is not allowed. And if it's not allowed, it should not be heard, it should not be considered, and it should be excluded and stricken from the record.
Just a couple quick points, Your Honor. We agree with counsel for Walton EMC, and we think it's not a question of whether you're a sophisticated fact finder or not. It's just a question of whether the expert testimony is necessary for your determination in this matter, and we argue that it is not and not allowed under Georgia law. And with respect to the argument that regarding Habersham and whether there was a proper Daubert challenge made, I think if you read the opinion in Habersham, Your Honor, will see that it was simply an objection, and there's no mention of a Daubert motion. It says specifically Habersham EMC objected that the expert testimony was neither required nor needed to interpret the above quoted legal terms. That's exactly what we're saying here. You don't need this expert testimony to interpret the act, and that whether a disputed premises is destroyed or dismantled is a decision for you to make in a legal conclusion, and that Mr. Blaine was not qualified to opine on such legal matters as the meaning of the specific language of OCGA 46-3-8B as applied to the premises in this case. So we think this is on point with Habersham, Your Honor, and for that matter, the testimony cited should be excluded. Thank you.
Now, that dispenses with all the motions, is that correct?
No, ma'am, we still have the motion for Georgia Power.
Okay, and now, okay, that was Walton EMC's motion in limine.
That's correct.
Okay, so now we're going to, so that's, I mean, okay, so what have you determined we're gonna take next?
Your Honor, we sort of assumed that you might rule on their motions, then resolve that question, and then we would take up the Georgia Power motion, but we can certainly do it in whatever order you prefer.
No, I'm gonna take it under advisement,
Okay,
all of them.
okay. Then we would move, I would think, to our motion, and
Okay.
since they've finished their argument.
So we'll
rebuttal
just do
on
one
theirs.
at a time, yeah, that's fine with me. That's,
Your Honor, we would enter that as our motion as well, so we would have completed their motion, Walton's motion, and Nestle Korea's
Okay,
motion
good.
at this point, and then we would defer to Georgia Power to argue their motion.
your motion in limine.
Yes, Your Honor.
Okay, and then we'll go to the motion, the objection to testimony.
We could do that, that's your
After
preference.
you do the limit, so we'll have that out of the way. Okay.
Judge Gibson, in some respects, our motion is an inverse of what you just heard that they argued. Where they're trying to exclude our experts, arguing that they are opining as to specific provisions of the act, they are offering testimony, which is the subject of our motion, which is essentially also going to an ultimate issue. But in their instance, they don't even begin to offer any credentials or any basis for offering the opinions that they are essentially crafting in terms of testimony. There are suggestions in these motions that they just argued that suggest to you that you can't consider testimony when it talks about the ultimate issue. But in the circumstances where we have, unlike the situation they have, they don't have any background for any expert testimony. And there are limits under the evidentiary rules for what kind of lay opinions can be offered. And one of the exclusions for lay opinions is expert testimony, not surprisingly, because it wouldn't make any sense under the code to allow wholesale expert testimony to be offered as lay opinion, but then have restrictions on the court's role as a gatekeeper when you're talking about expert testimony. So they're two completely separate buckets. Well, the bucket they're trying to pour their evidence into essentially does embrace an ultimate issue, but without the basis that underlies ours, which is true expert opinion. So what we have argued in our motion is that, for example, there is testimony being offered by various witnesses, and it's a theme, and they take issue with our motion in their response, at least Nestle's response. I don't think I've seen a response from Walton, but in terms of Nestle's response, they take issue as to the specificity of our motion. Well, we cite examples in the motion itself. We include objections in the objections to our testimony. And it would almost be impossible for us to go through and list every instance. For example, I'll just give you another example. In the testimony that's offered by, or pre-filed and rebuttal testimony offered by Ms. Miller on behalf of Nestle, she offers the opinion that the premises could not be reconstructed as a textile facility or couldn't be used as a textile facility. Well, there's no evidence whatsoever that she's ever even worked in a textile facility. So that kind of opinion testimony is yet another example, and it's sprinkled throughout all of their testimony. And the court can take into account, especially if it's looking at it and taking it under advisement, as to what testimony falls into this category. But it is a repeated theme where they're attempting, in the guise of lay testimony, to actually offer ultimate opinion testimony without the credentials that our experts have to offer opinions based on facts.
And you don't feel like you can do that through cross-examination?
We don't think that cross-examination doesn't exclude the testimony. It simply would go to a weight question. But we think here the evidentiary rules warrant excluding it.
Thank you.
Okay, thank you.
I'll be brief. In this particular situation, I think Your Honor sort of hit the nail on the head with your question. In a typical situation, if there is a challenge to the quote-unquote qualifications of a witness for his or her expert opinion, you're allowed to voir dire that witness. You're allowed to question that witness and see if you can show that that testimony is unworthy, is unreliable, and should not be allowed at that point. In this particular situation, I would submit, as far as the testimony goes, we have outlined the training, education, and experience of all of our witnesses as electrical engineers. And based upon that training, education, and experience, they gave opinions based upon evidence and facts that they knew to be true, or that they reviewed from other witnesses, or that they reviewed from other particular pieces of evidence. That's what's necessary. You talk about your expertise. You talk about why you have this special technical, scientific background. You tell them what that is. You tell them how you have it, how long you've been an electrical engineer, your education, your job, and based upon that, based on the facts that you reviewed, the evidence that you reviewed, you're able to give your opinion. Now, if their position is our witnesses who have been electrical engineers for years, work for Walton EMC, are not experts, that's something they can attempt to handle on voir dire. But based on the written testimony that has been submitted, we have submitted all of the evidence that is necessary for those witnesses to opine about the certain electrical engineering-based statements that they've made. So I would submit to the court that that motion should be denied as it relates to Walton EMC.
And by the way, I feel the same way about your motion, so I like to see it play out with, testimony and cross-opinion.
Not surprised to hear that, Your Honor. I'll be brief then. With respect to the motion filed by Georgia Power as to our witnesses, we disagree that it's expert testimony that's being offered. Under Georgia law, a witness is allowed to testify as to non-expert opinion testimony if those opinions are rationally based on the perception of the witness. All of our witnesses working at the Hartwell facility have extensive experience with Nestle Purina's processing and packaging for wet pet food. If the testimony is helpful to a clear understanding of that witness's testimony or the determination of a fact and issue, and not based on scientific, technical, or otherwise specialized knowledge within the Code Section 24-7-702. So we think, Your Honor, that the testimony offered is based on their personal experiences and their roles with the company and what they saw, observed, and did once they moved to Hartwell, Georgia, and began work on the significant construction project that is the facility there. And for those reasons, we don't think that the evidence should be excluded. Additionally, with respect to the testimony offered by Nestle Purina that Georgia Power seeks to exclude, they did not identify any testimony in their motion, and their objections that they made did not really cite to any of the arguments made in their motion. So it was very difficult for us to respond specifically as to which testimony they were seeking to exclude. And the mention of Ms. Miller's testimony today was the first time that they specifically identified that testimony. So for that reason alone, we think the motion should be denied because we're not sure what they're seeking to exclude. And we did specifically identify the testimony in our motion that we were seeking to exclude. Thank you for your time.
Just one point, Judge Gibson, and that's that 24-7-701A1 through 3, which is what was just discussed here, is very specific and says that lay testimony cannot be, quote, based on scientific, technical, or other specialized knowledge within the scope of Code Section 24-7-702. So as we argued initially, there are two buckets. The bucket they're trying to pour their evidence in, they haven't justified a basis upon which they can make those opinions. And so we would stand on our motion. Thank you.
Once again, we'll take it under advisement.
Thank you, Judge.
Who's next? And I'm thinking about going by date, if that helps y'all at all, but I think.
Doesn't matter.
Okay, I think you all filed at this point pretty much the same day.
Yes.
I know in limited you were early, EMC was early. So, it's up to you, or I can.
I guess, I don't know if just for kind of housekeeping matters, we have a a good number. I think they have a good number. Everybody kind of has a good number of things to which they're objecting. I don't know if a quicker or more efficient way to do it is to see if, whether based on the objections that everyone has presented, whether in some way that can be cleaned up as they're submitting their direct testimony, and if we still have that objection, we go forward with it in that way? Or do you just want to kind of go through them all right now? And it seems like we want to take some of this under advisement, and maybe a situation where either on cross or redirect or something of that nature, it may resolve itself. I'm just trying to figure out the
I
most
think that's
efficient way.
a wonderful idea. Do you
We
agree with
have
that?
no objection to that. It can either be resolved potentially through the testimony, or since you are going to take it likely under advisement, even
Right,
if you
and
wanted
I've
a
already
post-hearing
seen
brief or
everything,
something
Right.
like
so,
that.
you know, it's not like, so yes, I think that's a wonderful idea. And then we can talk about it after the testimony's in the record.
We're fine with that as well.
Okay. So, thank you for the idea.
No problem.
And,
Always here to help.
yeah. So, Mr. Edwards, call your first witness.
Yes, thank you, Your Honor.
It's underway.
I guess it's a preliminary matter. The Georgia Power filed a pre-hearing brief.
Yes.
We did not discuss with them to do so, we understand that, right? But we were wondering if, because of that, if each of the parties would be able to give a short but long response to that, no more than 5 minutes.
I think that's a good. When did you file
Excuse
that?
me, yeah, Georgia Power will make you want us to give an opening, or are you responding to our brief? Is that the point?
We were just planning to respond.
When
to
did
your
you
brief.
file the brief, Mr. Edwards?
Yes, yesterday, yes.
Yesterday. Was the pre-hearing brief on the notice of hearing and scheduling?
No, it was not. No, it was just offering for whatever assistance it is. So if you'd like to hear opening statements, we'd be happy to make one.
Well, it's been filed, so.
Yes,
That's in the record,
yes, I have it.
so I'd like to hear a response.
Okay, thank you, Your Honor. Again, I'm David Cook for Walton EMC. Walton stands with Nestle Purina in this matter. We stand with them in their efforts to bring an innovative food processing plant to an area of the state that desperately needed it. When Purina looked around to find a partner to provide electric service, they found that partner in Walton EMC. They found that Walton was accommodative, provided timely responses, and also Walton EMC would meet their 100% renewable objective. They were willing to help with that commitment. Walton was there to serve in a timely manner. So the issue in this case is whether or not Walton is permitted to do so. Can Walton properly serve this premises located in Hartwell, Georgia? And to put it in terms of the Territorial Act, it is whether or not Walton is entitled to serve them because the premises has been destroyed or dismantled and reconstructed not in substantial kind. So that's the magic language we're looking at. That is true an exception to the general rule, which is the grandfather clause. So as we noted, Georgia Power did file a pre-hearing brief. And in that brief, they cite a few cases such as Greystone and Jackson. And I would just point out, and I'll let Counsel for Purina discuss the differences in the facts of each case. But I will just say that the facts of this case are wildly different from the cases that they cite. So in order to actually get to the right answer here, we have to go to the proper standard and then apply the facts to that standard. So what is the proper standard in this case? Again, we look to the Territorial Act. Standard is destroyed or dismantled. Those are two options. And it must be reconstructed not in substantial kind. So what does it mean to destroy? Well, the Commission's prior cases have looked to the dictionary definition for one example, and it is there's the more strenuous requirement to cause something to end, to no longer exist, to cause the destruction of something. And then there's also the third definition, which is to damage something so badly that it cannot be repaired. So in the past, the commission has ruled that a premises was destroyed when it was destroyed when it was made unsuitable for prior purposes, and it was dismantled, which is the second element, through a systematic removal of the facilities, the equipment, and the furnishings of the old premises, including the production-related electric infrastructure. And with those changes, the commission found that the old plant was destroyed or dismantled, and that is, of course, the Southwire case, which we do cite. We think we have even stronger evidence here of a substantial change, not in substantial kind. But yeah, we do rely on Southwire. I think you'll find a lot of similarities. And then Georgia Power, I believe, does advocate for a standard that focuses almost exclusively on the destruction option, not the dismantle option. And by doing so, I think they read out the second option of the statute, which is to dismantle, which is obviously a lower standard to meet. And so I would submit that the proper standard here is we meet destruction, which I think we'll show, but we certainly meet the dismantle standard. So moving to the dismantle standard, what does it mean? The commission has said dismantled is obviously intended to cover the situation in which a premises is not destroyed, so it's clearly distinguishing destroyed, but deliberately taken apart. And the dictionary definition says that it is to take something such as a machine or structure apart so that it is in separate pieces. And so another dictionary definition is to take to pieces, to destroy the integrity or functioning of. So there is a functional aspect to this as well, which you will find in prior commission cases. So to put it, to summarize the standards related to dismantle, it is in the context of the grandfather clause means to deliberately take apart a premises so that it is in separate pieces, or to destroy the integrity or function of that premises. So if we show...
So you're using dictionary definitions?
That's right. Well, the commission in prior cases have cited dictionary definitions.
But, so, how much is that from the dictionary, and how much is it from case law? What you just...
Oh, what I've just said. Some of it is case law. I think when I said it was defined in a dictionary
Yeah,
as
you
such.
did on a lot, but it seems
But
like
then I did
contrary
cite
to
some
your colleague.
cases, like the Southwire case. In the Southwire case, I did say, when I talked about the building being destroyed because there was a systematic removal of its facilities, infrastructure, and equipment, that is a prior case. That's right. Now, if we show destroy or dismantle, we also need to show that it was reconstructed not in substantial kind. If it is reconstructed in the same kind, then it is not an exception. Insubstantial kind means a facility which is largely but not wholly of the same fundamental nature or quality as the previous facility. That is a commission statement. And we're taking the negative here, which is we just have to show that it is not insubstantial kind. I think the commission has said if it is reconstructed and united by common traits or interests, it is constructed in substantial kind. So in looking at the case law and commission rulings, the commission notes there are two types of results. One is when the cases generally involve a premises in which the old building is either expanded dramatically or replaced altogether by a new building, but retains the same basic function and nature. That's one line of cases. The other cases are situations in which the new, expanded, or reconstructed facility is of a different nature and function from that of the old facility, and is therefore deemed by the commission to be of a different premise and not constructed in substantial kind. So I would submit also that the relevant common traits or interests are those that go to the function of the premises, which you will find here has been changed significantly. Final point here is you'll hear some testimony about, we think, about the permanent versus temporary nature of the service, of electric service. And we think that may go to Georgia Power's position that maybe Purina is bound by that, by taking a permanent service or not if it's temporary. So I think it's important just to note what is the standard for making a choice under the Territorial Act. What do you have to do that? And I'll just quote from a case. It would be unfair, and this is from a court of appeals, if a large load customer could be bound to receive service from an allegedly chosen supplier absent a binding agreement reached through mutual assent and meeting the other requirements for contract formation under Georgia law.
Now, all this is in testimony, right? I mean,
That's correct.
that was in rebuttal testimony, so I'm not understanding what point behind that.
Well, I'm talking to the standard. Like, what is this? What are you supposed to rule on when it comes to whether or not Purina has made a choice or not?
Okay.
And I'm saying that's the standard. We would look to a contract.
Right.
So with that, I would also make a policy argument that the exception to the grandfather clause is important because it does encourage, it encourages other than greenfield construction when industrial customers seek to come to the state. With that, I'm going to hand it over to Purina's counsel.
Thank you. And I understand that a lot of what you've heard is in the testimony, so I'll try to be concise, Your Honor. With respect to the standard cited by Walton EMC, we agree with that. We believe the focus is on the dismantling of the premises as it existed when our client took possession of it and purchased it in 2017 for $7 million. We think that Georgia Power's reliance on the Greystone case is misplaced, Your Honor. In that case, the facts are clearly not on point with the issues here. That was a facility that was purchased. Some Keurig installed some pod manufacturing equipment in about a third of the facility. They discontinued that production line as a company decision, removed the equipment, were marketing that facility as a warehouse. That was when the case was heard before the hearing officer and commission. So by the time it was heard, it had essentially been reversed back to what it was when Keurig had purchased the facility. So we don't think that is the case at all here. What we have is a facility that was purchased. It was previously a textile manufacturing facility. Our client has made substantial investment in it, almost $300 million. It has been reconstructed, not in substantial kind. It is now a food-safe environment. The construction continues. They are building a new 100,000 square foot building. And with respect to the cases that the commission has heard regarding the Territorial Act, we believe that Southwire is the clearly most analogous case where there were substantial fundamental changes made in the purpose of the facility. We think the evidence here will demonstrate that extensive and capital-intensive changes made to the Hartwell facility, driven by the radically different manufacturing process that it will house, more than meet the commission's standard for finding that a new premises exists in Hartwell, Georgia, Your Honor. There are different customers, there are different products, there is a substantially different environment for food processing and packaging. We have different needs, and we have created a completely new premises and facility there. We believe the evidence here will show that today and tomorrow, and that the evidence will show that our case is on point with Southwire. For those reasons, we believe that it is our right under Georgia law to have a choice of our electric services provider. I would note for the record that as to for the stipulations that the 900 kV at connected load requirement has been met by stipulation, and so that will not be an issue in the proceeding. The issue will solely be as to whether the premises was dismantled or destroyed and reconstructed in substantial kind. We tender to you, Your Honor, that the evidence will show that.
Thank you.
Thank you, Your Honor. As you'd expect with learned counsel, there really isn't that much disagreement. What you just heard from counsel for Nestle, that this case is about whether it is destroyed or dismantled first and then reconstructed in substantial time, is the focus of this case, not questions about whether somebody thinks somebody might be a better electric supplier or might offer better rates or are unhappy somehow in the relationship. We do have some disagreement on the statement of the legal standard, and that starts with Mr. Cook's statement and both counsel, that there are two subsections of the Act that apply to this. In order for Walton EMC to extend service to a premises that's not in its assigned area and where it doesn't have rights, it's got to show that it's a new large load premises. And we stipulated that the electrical load is not the issue. This is a very big facility with a lot of electrical load. But the newness of it is they have to show new. And they skipped over that in their discussion to you of the standard. Our brief highlights that and highlights also that the Commission in its most recent decisions in this area has highlighted the fact that it must be a new premises, a new building structure or facility, not an old one. Now, there's also subsection B, 8B, which lets the supplier that has been serving a premises continue serving that premises exclusively, regardless of its size and regardless of its newness. And that also includes a premises that has been destroyed or dismantled and reconstructed in substantial kind, which is now where we're together again. The other fundamental error you heard in the argument you just heard, but I think it was in a way corrected, was when Mr. Cook said that dismantled was a lower standard than destroyed. He is wrong. Destroyed or dismantled is a phrase of the Act, and the meaning of a word is taken from its company. And later, when he read from the Atlantic Wood case, the Jackson EMC case, correctly, he said what dismantled means is you've done the same thing as destroy it, you've just taken it apart in an orderly way. So they are equal, and you know they're equal because you've got to somehow also show that you've got a new premises. So dismantled is not some light standard, nor is the case they're citing, Southwire, a destroyed or dismantled light case. It is a case where the Commission found not just that the facility couldn't be used for a particular brand of product or particular type of product, but that it had been fundamentally destroyed with respect to its prior usage, such as a distribution warehouse. And so destroyed or dismantled mean the same thing, and the Commission hasn't changed that. This case is not about a greenfield building. It's a building that's existed. It is a case where that was not destroyed or dismantled by any means and then was bought by Nestle Purina. The suggestion in Mr. Cook's testimony finally is a straw man about whether somebody chose Georgia Power Company or not. Under 8B, Georgia Power was the assigned supplier from day one with a permanent service right and obligation to that facility. And the straw man that they set up with the case they read concerned a case where the consumer using the premises had not been served and where the facilities were not serving load. Whereas here, the facts will show you that indeed, that when Nestle bought this facility, while it has done construction and it is still building a new separate building, it has, from within a few months, been the consumer using this premises and using it for the same types of operations as it had been before distribution warehousing. Thank you.
Your Honor, just briefly with respect to the last comments that Mr. Edwards made, Mr. Cook touched on this. We believe the evidence will show that any discussions that Nestle Purina had with Georgia Power, any service that was taken, was clearly understood by all involved to be for construction, the majority for construction activities, and that the load that was being taken was being used to do perform construction activities on the site, and any other loads were nominal. We think the evidence will clearly show that, and that Georgia Power's own witnesses, through documents, made clear that they understood that permanent service had not yet been set up.
Thank you. So, Mr. Shuttle, would you now,
Georgia Power Company would like to call its first witness, Harold Lawson, and if we could get some help with getting the posters out, while he's getting sworn in, if that, can we get our demonstratives up? The big pictures, the big photos. Mr. Lawson, if you'll come sit over here. And make sure you've got a microphone that's live. You might have to be in that corner seat. I don't know which. Oh, it does? Yeah. I think it matters that the hearing officer can hear you. Let's make sure.
no,
No.
you know, I think you have to push it down. I gotta fix it.
Thank you. Yeah. But they would serve on the hearing officer and be viewed as demonstratives.
They're not.
You're not doing the camera.
Would you mind?
Yeah, that's one of them, yeah. And, no, no. Don't you have the old photograph?
Trying to get somebody coming speak up and I'm sure I can hear you.
I can barely hear you,
Oh,
even with the microphone.
That's exactly right. I can barely hear it.
really?
Yeah, if we don't have the microphones, it's gonna be really good. You want me to go up and talk to her?
I just talked to her, and then I told her I'd call Max, and I don't have his number in this phone. Would you mind doing that?
Look for, we just have a focus mic over there, but it's not over there.
It's not. I can sit over here.
Yeah.
Well, but I gotta hear too.
I'm
We can all have the problem.
Oh,
Is mine not working?
yeah.
Mine's not working very well. Can I keep that up there? Oh. We're gonna figure something out.
I don't know if it'd be a problem for the witness to sit
Yeah,
there.
I mean, he could just sit up here.
Yeah, that's,
Do you mind coming and joining me?
I will.
Please do. Just on that last one. Sure.
Well, fix that.
This is funny. Can you hear me better? Okay. This is just,
makes it work.
do a little workaround here.
Boy, these are the most uncomfortable chairs I ever
And
sat in.
I've got all kinds of pillows in here.
We ready?
Yes.
Okay, thank you. We'd like to call Georgia Power Company's first witness in docket 22509, Mr. Harold Lawson. Mr. Lawson, would you raise your right hand, please? And do you swear the testimony you're about to give is the truth, the whole truth, to the best of your knowledge under God?
I do.
And would you please state for the record your full name, your employer, and your responsibilities?
My legal name is Harold Daniel Lawson. My friends call me Buddy. I am president of Sterling Development and Engineering Corporation. We've been in business since 1987.
Thank you. On August 16th of this year, did you pre-file or cause to be pre-filed 13 pages of direct testimony in question and answer format and 2 exhibits?
Yes, I did.
We'd like those exhibits marked as Georgia Power 1 and Georgia Power 2. On August 26th, did you pre-file or cause to be pre-filed 6 pages of rebuttal testimony in question and answer format?
I did.
And you didn't have any exhibits with the rebuttal, did you?
That's correct.
And we filed on September 3 a short errata to your direct and rebuttal testimonies, correct?
Yes.
And do you have any other corrections you want to make to your pre-filed direct and rebuttal testimony or exhibits?
Well, I wasn't expecting that question, but I don't think so.
Okay. If I were to ask you the same questions today under oath, would your answers be the same as set forth in the pre-filed testimony as corrected?
Yes.
Okay, thank you very much. Mr. Hearing Officer, I'd like this time to move Georgia Power Exhibits 1 and 2 into the record, subject to cross-examination and any further motion.
So moved.
Your Honor, it's subject to the motions in limine and objections that are pending. We have
Oh, of
no
course,
further
yes.
Thank you. And, Ms. Hearing Officer, the court reporter has previously been given a copy of these pre-filed direct and rebuttal testimony. I ask that the testimonies of Mr. Lawson be copied into the record as though given today.
Yes.
Mr. Lawson, have you prepared a brief summary of your testimony?
I have.
Would you proceed with your summary, please?
Yes, thank you. My direct and rebuttal testimony confirm and discuss an expert report I prepared dated August 6, 2019. Prior to submitting my report, I visited the Springs Industries facility on July 29, 2019, which is now owned by Nestle Purina. My testimony states my opinion to a reasonable degree of engineering certainty that the Springs Industries plant is neither destroyed nor dismantled, nor has a new building been created by Nestle Purina, nor has Nestle Purina altered the Springs Industries manufacturing plant in any way that would preclude its prior use or made available for another manufacturing and warehouse facility. My report and testimony describes how in 1991 Dundee Mills constructed a 348,000 square foot facility to manufacture and produce towels, warehouse raw and finished goods, and distribute these consumer products to their customers. The facility included a 190,000 square foot warehouse and distribution facility, as well as almost 150,000 square feet of manufacturing and facilities support rooms and a maintenance shop. In 1999, Springs Industries constructed a major 200,000 square foot expansion for weaving to allow the facility to become more vertically integrated to manufacture of towels. My company performed all of the engineering and architectural design for this new facility. We also provided construction administration services for Springs Industries, which included administration of multiple contracts, including site work, grading and utilities, building steel fabrication and erection, insulated precast concrete exterior wall panels, and electrical power distribution, roofing, mechanical plumbing, air conditioning, and filtration. In 2002, my firm provided the engineering design and construction administration services for a new air compressor building on the east side of the weave plant. In my report, there's a figure on page 4, figure 1, that includes a sketch of the manufacturing facility. During my site inspection on July 29, I observed that Nestle Purina retained all of the exterior walls of the weaving plant building and the original construction by Dundee Mills. The weaving plant manufacturing required a high relative humidity environment for efficient and quality weaving of fabric. At 65% RH, the exterior walls and roof required design to prevent moisture condensation on the walls and on the manufacturing area ceiling during the cold winter months. The walls are insulated precast concrete with a high thermal resistance to maintain interior wall temperatures above the environmental dew point. The roof includes a moisture vapor barrier with insulation to provide the same thermodynamic performance. Along with the walls, the roof remains intact over all the facility manufacturing and warehouse areas except for the replacement of the bleachery roof. The original air conditioning system for the Springs Industries plant included 800 horsepower refrigeration out of one machine, a centrifugal chiller, air washers and air handling systems, pumping systems, cooling tower, and filtration equipment and systems. Nestle Purina is replacing this with much smaller equipment and systems to control temperature only, which will allow for a maximum relative humidity in the summertime. And all this is described on the few drawings that we received for review from Nestle Purina. There's not any control of relative humidity in the wintertime according to the drawings that we received. The underfloor ductwork that was used as part of the Springs Industries more sophisticated air conditioning and filtration system remains intact and can be returned to service very, very easily. The air conditioning equipment serving the bleachery and cut and sew areas remain in place as originally constructed and installed and are in excellent condition as we observed during our plant visit. During the site inspection, I was able to verify Nestle Purina's expected electrical power supply to be approximately 28% greater than that was furnished to Springs. However, we also confirmed that the electrical loads in the plant are almost identical. Springs had a load of about 9,722 kVA, and Nestle Purina's documents show 9,769 kVA. They're almost identical. I was only able to verify that the original power supply that Georgia Power Company installed in 1991 on the east side of the cut and sew area is still in place. Drawings for the weaving plant area from Nestle Purina that was made available indicate that contractors had discretion removing wiring and conduit for installation of new lighting fixtures. It appears that the new light fixtures were installed in the same junction boxes that was originally installed for the lighting and weaving in the warehousing area and other manufacturing. These lighting changes are very consistent with typical lighting upgrades that we observe in manufacturing facilities all over the country. And they're doing it for energy savings. My site inspection observed haunches installed on the columns that we installed in 1998 for 2,000-pound hoists and monorail. There's no substantial change in the concrete flooring except for a small portion being replaced to install underfloor drains. The haunches are still there and can be reused for cranes, again, just like it was. The compressed air facility remains in operation. In July, I observed Nestle Purina continues to use the original cooling towers along with the original 9,000-gallon compressed air receiver we installed for Springs in 2002. The original fire protection sprinkler piping risers are in place, and most all of the overhead sprinkler piping remain as originally designed for the Dundee Mills and Springs Industries buildings. The plan drawings forwarded to us through Georgia Power by Nestle Purina for review show minor rerouting of underground fire protection on the east side of the building for installation of new transformers and rerouting on the west side to accommodate construction. Minor rerouting of stormwater drainage piping systems were observed for the same reasons as underground fire protection. The original stormwater retention pond is still intact and being used. Wastewater treatment equipment was replaced for the Nestle Purina facility for a specific waste. The waste which the Dundee Mills generated was totally different, and so they had totally different equipment in the waste treatment facility. However, the aeration basin still exists along with a clarifier. The basic system remains in place. A chemical tank farm infrastructure remains in place. On January 28, I toured the Springs, or not January 28, 2018, I toured the Springs Industries facility with a representative of Nestle Purina. The facility was not dilapidated as stated by others. It was in excellent condition, consistent with photographs shown in the March 2016 appraisal Nestle Purina provided. In summary, Nestle Purina has not altered the Springs Industries manufacturing facility in any way that would preclude the prior use that was made of the facility. The plant's principal features are being used by Nestle Purina for manufacturing and warehouse and distribution, and they are not destroyed or materially changed. The plant can be used by other manufacturing concerns, including textile manufacturing and distribution, which is a much heavier manufacturing operation. This concludes my summary.
Thank you, Mr. Lawson. Your Honor, he's available for cross-examination.
Ready to proceed, Your Honor, or if anyone needs a short break for personal convenience, we can do that as well. Whatever.
How long do you have? A
How
lot?
long do I have?
I mean, how much cross?
We'll finish before noon.
Let's try to go keep going.
Okay.
Can you suit you?
Hey, I'm at your disposal all day.
I think we'll wait till noon and then break for 45 minutes.
Good afternoon, Mr. Lawson.
Is it afternoon?
We met at the plant on July 29th, is that correct?
Yes.
And as I understand it, you've been engaged by Troutman Sanders in this matter, is that correct?
Yes.
Prior to your engagement by Troutman Sanders in this matter, your company was engaged by Nestle Purina at the Hartwell facility, is that correct?
Yes.
And you assisted them with a little bit of engineering work, including reviewing what was left of the Springs factory?
The only engineering work that we did was drafting. There was no design, and that was to locate fire protection risers in the warehouse area and ventilation dampers so that so that Nestle Purina could lay out the facility for their storage.
And at some point, you and Nestle Purina determined that you would part ways, is that correct?
Not that I'm aware of.
You're not currently working for Nestle Purina, are you?
No.
And shortly after that, you came to work for Troutman Sanders against Nestle Purina, correct?
Shortly after that? Oh, no, it's been a good while back.
Okay. But after your work for Nestle Purina, you came to work for Troutman, correct?
Well, that's one of many clients I have, yes.
And as I heard your testimony and your summary of the testimony today, it sounds like you're very proud of the facility at Hartwell and your involvement in it, correct?
I suppose I am, and I can assure you we made mistakes. We weren't perfect, not perfect now, but yeah, it was a really fine endeavor.
And that was when it was used as a textile or a towel manufacturing facility, correct?
Yes.
And during the tour on July 29th, you were disappointed at some of the changes that were being made to the facility, weren't you?
No, not that I'm aware of.
You expressed that disappointment to Miss Miller, didn't you?
Who's Miss Miller?
Rachel Miller, she's the
Yeah.
factory manager.
No, I mentioned to her that I was surprised that Nestle Purina didn't use some of the air conditioning equipment. And I was surprised that because it was so sophisticated compared to what you're installing now.
And Nestle Purina has removed the HVAC equipment, specifically all the equipment that's in the manufacturing area, is that correct?
No, they're still installed for the towel cut and sew area.
Is that the area that was in the mezzanine area that we toured?
Yes.
Do you know whether that equipment has been removed as of today?
No, I don't. I know that when I was there, it was still there.
So you would not know if it has been removed since your visit on the 29th?
No, was it?
That's not for me to say, you know.
Oh.
Mr. Lawson, that'd be for other witnesses.
Yeah, he asked the question.
Okay. Okay, thank you.
And when you toured the facility on the 29th, that equipment in the mezzanine area was not being utilized, and you were told that, correct?
That's correct.
And you indicated that the HVAC system that is an air handling that's being installed by Nestle Purina, you said it was smaller than that was used by Springs?
Yes,
And that's primarily because the Springs HVAC and air handling, one of its primary functions was to remove lint from the manufacturing area, correct?
that was a secondary function.
Removal of lint is an important function of an HVAC system in a textile factory, correct?
That's a secondary function.
It's not
Pri-
important.
No, primary is to control the environment, temperature, and relative humidity. There are many textile plants that do not have the filtration system that we installed for Springs and operating just fine.
But the Springs facility had a significant lint removal system, is that correct?
It was.
And that is no longer a part of the facility, though. That's been dismantled.
That's correct.
You indicated in your testimony and in your summary that you had reviewed certain drawings that you were provided by counsel? Is that correct?
Yes,
You do not know if you were provided all of the drawings received by Troutman, is that correct?
that's correct. I assume that they forwarded everything to me that they received.
And you talked about in your direct testimony in your summary that there was an air handling system in certain parts of the manufacturing facility that had holes in the concrete floor and then had medium-sized or 18 to 24-inch tunnels underneath the floor. And then there were also much larger tunnels, 84-inch tunnels. And all of that was part of the air handling system at the Springs facility, correct?
Yes,
And in your direct and rebuttal, you mentioned that the holes in the floor had been filled with concrete.
that's what I was told.
Did you see that the holes had been filled with concrete?
I saw the holes were filled. I can't tell you what it was.
Understood. And did you read the rebuttal testimony of Mr. DiMartino in this matter that was pre-filed?
Yes,
And did you see in that testimony that Mr. DiMartino testified that the 18 to 24-inch tunnels underneath the flooring had also been filled with concrete?
yes,
And in order for that air handling system with those tunnels to be reused, both the holes in the floor would have to be drilled, and those 18 to 24-inch tunnels would have to be either replaced or the concrete somehow removed from those metal tunnels, correct?
no,
So those 18 to 24-inch tunnels are not necessary for that?
no,
So your testimony is that all that is necessary is the holes in the floor and the 84-inch large tunnels?
no. The testimony is that with weaving machinery, it's easy for us to duct the heat and the lint collection off of that machine to those 84-inch ducts. The new technology allows us to do that without any difficulty or interference with cranes or monorails. So it'll be very, very easy for us to put weaving back in that facility without using those branch ductwork.
So you're saying that the ductwork that you testified about in the direct and rebuttal is not necessary?
I'm saying that the branch ductwork that was filled with concrete, we can overcome the issue of installing weaving machinery in there or anything else like spinning frames that we do the same thing with in collecting dust and heat from the motors. It's easy for us to duct it to the underfloor tunnels a short distance without any difficulty.
So that would be a different system than what was previously used at the Springs facility, correct?
Principally, it's the exact same system.
But it would not utilize all the ducts that we just discussed.
It would not utilize the little bit of branch ductwork that's under the floor.
With respect to the construction that's ongoing at the site, when we were both present at the site on July 29th, you observed that there was a new 100,000 square foot building being constructed, correct?
I didn't know what size. I saw where steel was going up for a facility adjacent to the weave plant.
And that facility or that building is not mentioned in your direct testimony or report, correct?
That's That's probably correct. I'd have to go back and just make sure.
Why didn't you consider that in reaching your opinion?
I was focused only on the existing facilities, its infrastructure, its construction, and how it's being used. That addition, I don't know what you're using it for. I don't know what it is for. And so there was really no need in me commenting on it because I don't really know anything about it. At the time, I didn't know anything about it other than you're building a building. I didn't know what it was for.
But you did observe the steel beam framing and foundation that had
I
been-
did.
And you did not mention it.
I'd have to go back and look, but I don't think that I did.
And your testimony is that you don't know what that building will be used for, correct?
At that time, I didn't know.
But now you know that it will house two additional production lines, correct?
That's correct.
You mentioned that the only roofing that you observed that had been changed at the facility was over the bleachery, the new cooler and freezer building, and the new canning building. Is that correct?
That's correct.
I believe there might be one other building as well where the roof was replaced.
Which one is that?
It's escaping me at the moment, but I believe it was one of the treatment buildings.
Yeah, I didn't observe the roof on the treatment building.
And do you know what type of roofing material has been installed there?
I do.
What is that?
The weaving plant and the
No, I'm sorry. My question was, do you know what the new roofing material is?
it's a rubberized roof.
It's a different type of roofing system, correct?
The membrane is, but I don't know what's underneath it.
The Springs factory has a ballasted roofing system, correct? That's a roofing material that's held down by weighted material put on top of it.
Yes.
And the new roof is not the same.
I don't know what the new roof is constructed of, so I can't answer that.
And so you don't know whether it's a mechanically fastened roofing system.
No, I do not.
And you don't know how that type of roofing system might be better suited for food-safe environments, do you?
I do know.
Why is that?
The roofing that is on the weave plant is the best roof you can put on, second to coal tar pitch. That roof has lasted 30 years. Same thing, well, no, since 98, so that'd be about 20 years. And it's got another 10, 15 years life left in it, from what I saw. There are no blisters on it, and moisture is not getting in between the membrane and the vapor barrier. On a mechanically fastened roofing system, you have eliminated your vapor barrier. And what occurs with moisture, it will get into that membrane and you will see blisters. And that's from the history of that type of roofing system. And we have replaced many, many roofs of that type.
Have you ever worked on a wet pet food manufacturing facility before, Mr. Lawson?
No, I have not.
So you don't know what type of roofing systems they typically employ?
No, I don't.
And you don't know why they do that?
Well, I'm sure that they do it for cost, and I'm sure that they do it because they don't need moisture control inside the building.
But you don't know what it has to do with food safety because you're not familiar with those type of requirements, are you, Mr. Lawson?
No.
With respect to the flooring, I believe you testified that a small part of the flooring was replaced in the Hartwell facility, is that correct?
Yes.
And that was actually 79,000 square feet of flooring, correct?
I don't know how many square feet. I know that it was a small amount compared to the whole facility.
It was roughly 20% of the facility where the flooring was torn up and replaced, is that correct?
If you'll give me the numbers, I'll calculate it for you. Unless you already have, and you say you have, I'll trust you that you did.
I thank you. I appreciate that, Mr.
Okay.
Lawson. With respect, I'd like to show you what's been marked as, previously marked as DiMartino 1 that was submitted with the direct testimony of Mr. DiMartino. If you could show that. As part of your work in this matter, did you review Mr. DiMartino's direct testimony?
I did.
Yes, and does that picture show the flooring that was torn up?
I don't know where these pictures were taken, but I see dirt, I see the grade, I see trenches, but I don't know where they were taken.
That's inside of the building at Hartwell, correct?
Like I told you, I don't know where they were taken.
So you don't know where the flooring was replaced in the facility?
When we walked through it, the lady that toured us pointed them out to us.
Is that Ms. Miller?
Miss Miller. I think we called her Rachel.
Correct.
Okay, I didn't know her last name.
That's okay. And with respect to that flooring, that was torn up and replaced with thicker concrete flooring, correct?
I don't know that.
But you did mention in your testimony that slot drains were installed in that flooring, correct?
I testified that there was a mechanical piping installed for floor drains, yes.
And that has to do with the needs of a food environment to drain off some of the wet water that comes out of the pressure cookers, in addition to the water that's used to water and chemicals that's used to clean that equipment. Is that correct, Mr. Lawson?
That's what I was told. It's the same thing we do with slashers that was in the area close by.
And was anything in the Springs factory at Hartwell designed to be ingested by humans or animals? Any of the product?
Would you repeat the question?
Was any of the product that was produced by the Springs factory, none of it was designed to be ingested by humans or animals, correct?
I don't think so.
It was towels mainly?
Well, it was towels, but there was a lot of other chemicals that they used, so I can't confirm yes or no to your question.
It was not a food-safe environment. They were not
No,
processing
it
and
was
packaging
not a
food.
food-safe environment.
And that's the significant difference between what Nestle Purina is doing in their facility and what Springs did in theirs, correct? Nestle has a food-safe environment.
Well, first, I don't know the definition of food safe. I know what it means to me, but I can't tell you the definition in the industry.
And you're not familiar with the FDA requirements that govern the production of wet pet food manufacturing, are you?
Not wet food. I do for sutures in some medical facilities, but not pet food.
And sutures are not designed to be ingested.
No, although it is cat gut.
Do you understand, or do you have any information regarding how the air flows through the HVAC system at the Nestle Purina facility currently?
I can only tell you what I saw and what I saw on drawings.
And which way does the air flow in the Nestle Purina facility?
I assume from the drawings that you put in an air handling unit and you're discharging air out through ductwork on the east wall.
So you don't know if what amount of recirculation is used in the facility?
No, the drawings didn't show that.
And you don't know whether recirculation is something that should be avoided in a food-safe environment?
No, but common sense would tell me that there must be some kind of restriction.
And that would be to avoid contaminants or pests from being recirculated back into the food processing area, correct?
Well, I don't know that. I just assumed that it would be.
You testified about the lighting system, and it was your testimony and your statements in your report that that system was replaced only for energy efficient. Is that your testimony?
No, that's not my testimony at all. My testimony was that it was replaced for energy efficiency and energy savings. But if there was another reason, for example, lighting levels, your lighting levels was no different than the lighting levels that we had in the Springs plant, even though that was high pressure sodium. So we had to have we had to have heavy lighting in there, but it looked like the same.
You don't know whether glass is allowed to be used in a food processing area, do you?
Say that
Do
again?
you know if glass lighting is something that is allowed in a food processing area, do you?
Just from common sense. My common sense tells me that it would not.
And whether filaments would be something that you would want in a food,
Be common sense again.
that you would not want filaments.
That I maybe wouldn't. I think it kind of depends on the fixture. For example, high-pressure sodium, you can put protective covers on them that if glass does break, it can't fall to the floor. And we do that a good bit.
But you didn't see any of those covers in the lighting system at Hartwell, did you?
That Nestle Purina replaced.
Did you see any of the covers you described at the Hartwell facility when you visited on July 29th?
No, that lighting was gone. Now, we were talking high-pressure sodium. I think you got LED lighting now.
Right, but you described covers that would minimize any glass. Those covers were not present.
For high-pressure sodium.
Right. And they were not present when you visited the site, correct?
The lighting fixtures were not present that we installed, no. They were installed there in January of 2018 when I visited.
But they have been removed since that time, correct?
Yes.
You're aware that Walton EMC is installing a new substation to service the plant, correct?
I was told that, yes.
You mentioned in your direct testimony that you thought the amount of power that Nestle Purina would take at 9.7 megawatts would be the same amount that Springs took. Is that correct?
What I testified was the load that Springs had was a certain number. I think it was 9722, and that the load in the plant for Nestle Purina, according to the documentation they gave to us, was something like 9769, something like that, kVA.
You're not aware of how much power Georgia Power said it could guarantee Nestle Purina, are you?
You're talking too low for me. You need to repeat the question, please.
Objection.
What's the basis of the objection?
In the form of a question. No guarantee issue in this case.
Your Honor, I think the question goes to his knowledge and his
Can you
direct...
repeat the question?
Sure. Mr. Lawson, the question is, you are not aware of how much power Georgia Power told Nestle Purina that it could guarantee could be delivered to the Nestle Purina facility in Hartwell?
You are not aware?
Yes.
Not specifically, no.
You were not privy to those discussions, were you?
No, sir, I was
I
not.
don't see it involved. So, thanks, is the answer.
Thank you, Your Honor. And you weren't involved in any discussions between Georgia Power and Nestle Purina regarding potential terms of service and electric service delivered to the facility in Hartwell, were you?
No, I wasn't.
With respect to the bleachery has been demolished in parts and concrete poured into many of the vats that are in that area of the plant. Is that correct?
Yes. Well, I don't know that it was fully enclosed or filled with concrete. I believe they probably put sand or some other base in, then then put concrete in it.
But the bleachery vats have been filled,
Yes,
and you observed that.
yes.
The air handling system that we discussed that involves the ducts underneath the flooring, part of that air handling system was located in the same place where Nestle Purina's offices and employee center are now located. Is that correct?
The underfloor ductwork?
The air handling equipment itself, the machinery,
Yes,
and that has been removed.
yes,
And in its place, Nestle Purina has installed office space and an employee center, correct?
yes.
I'm going to hand you what's been marked as Miller Exhibit 1. It was attached to Rachel Miller's pre-filed direct testimony.
Yeah.
I think that is what ours set,
Oh.
so that's necessarily set. I'll try to guide you with that.
Mr. Lawson, are you familiar with this document?
I haven't seen the document you're talking about.
Okay, if you would, have you had a chance to look through it?
The only document I have is what you gave me earlier,
Okay.
which shows some pictures.
Nick. Nick.
May I give you these, return these to you?
Sure. Mr. Lawson, let me know when you have a chance to look at that document that's marked as Miller 1. It's attached to Ms. Miller's pre-filed direct testimony.
I have given it a cursory review.
Are you familiar with that document?
No, sir.
If you'll look at the document and look at the equipment listed in it by room, tell me if that seems familiar to you based on your experience at the Springs factory.
Opening and blending was not part of the Springs factory. The office furniture, fixtures, and equipment was. There was no card room or card equipment. There was no spinning frames. There were no spoolers. Weaving, we had airjet looms. What you're showing here is not airjet looms. The cloth room,
With respect to the airjet looms, those have been removed from the Springs factory, correct?
yes. What you have listed for the cloth room is not what Springs had.
Has the equipment that was used in the cloth room when Springs used the facility in your time period, has that been removed as well?
Well, all that there were in the cloth room. Now, let's define where the cloth room is. Where's the cloth room you're talking about?
I'm talking about the cloth room that you're familiar with.
We never called anything a cloth room, so I have a sketch here. If you'll point out to me what part of the building you're talking about.
I think the general question is, Mr. Lawson, is the manufacturing equipment that was used to make the textiles and towels at the Springs factory, has that all been dismantled and removed?
Yes. The shop equipment, there may be some of this equipment that was there, but it wasn't there when we made our visit.
But you're not sure either way whether that equipment is present?
Well, I know that there's no shop equipment present. We went down to the shop and it was empty.
It's all been removed?
Yes, sir, as far as I could tell. Laboratory, never been in their laboratory, but this sounds like similar equipment we see in textiles. And I couldn't confirm to you about the yard equipment.
But to be clear, all of the textile manufacturing equipment that you had observed in your work with the Springs factory had been dismantled and removed at your visit on July 29, 2006?
Yes, sir.
19.
Yes, sir.
You're not familiar with the water treatment requirements for the processing of organic or food products, are you?
Only from what I read in submittals that Nestle Purina provided. I didn't pay a lot of attention to it because I knew that it was different than the treatment in textile waste.
And therefore, there would need to be a new wastewater system for that reason.
There
to
needed
treat
to
the-
be a new wastewater treatment machine, which would allow different chemicals to enter and to treat it.
And that would be to prevent the discharge of organic materials from the plant, correct?
I can't tell you that because I didn't see what the pretreatment permit required.
But that is different than the wastewater treatment facility and system that was installed and used by Springs, correct?
I cannot confirm to you that the pretreatment requirements for Hartwell was any different for Springs, because I don't know what those two pretreatment requirements are.
That's because of your lack of familiarity with the food safe requirements and the requirements governing the discharge of organic materials?
No, it's because I have not seen the pretreatment requirements by the city of Hartwell or EPD.
And are you aware of any of the food safe requirements relating to the discharge of organic materials that are required to be followed by a wet pet food manufacturer such as Nestle Purina?
Be a little more specific for me.
Federal requirements?
What kind of requirements?
Federal requirements?
No, sir.
You're not familiar with those?
No, sir.
With respect to the use of the term culinary steam, do you know what that means?
Specifically, I would probably be wrong, but I'll tell you what I think it means. Because I think of chefs in a restaurant that have to sterilize their knives and spoons, etc., and you would put them in a small autoclave and you would sterilize it, just maybe like the autoclaves that I saw going in at Nestle Purina, which we have in textiles also.
But culinary steam would be steam that was safe for human consumption, correct?
That's what I would think.
And with respect to the machinery that's used in the food processing area, are you aware of the requirements related to lubricants for those type of machinery?
Aware of the requirements for what?
Lubricants
Lubricant for steam?
for the machinery related to food processing.
Other than it's got to be food safe in case it gets in with the product. You got to be careful with it.
I don't have anything further at this time, subject to redirect, Your Honor.
Thank you. Mr. Edwards? How much redirect do you have? I'm about...
10 minutes, yeah, about noon.
Okay.
Yeah.
Don't go over.
No, I won't. Mr. Lawson, you were asked some questions about the bleachery and bleachery roof, and also about a new building under construction. So for our purposes, I want to kind of reset the table about which building is which. Now, I'm going to show you a photograph we have here from a January 27, 1993 photograph. And if you could identify the building.
Excuse me, Mr. Edwards.
Can I just move so I can see?
Sure.
If you could identify this area here. would
That's
that-
a warehouse and distribution center. And off to the south of it was a small office area.
And then, which is this area over here?
That's where they cut and sewed towels.
Yeah.
And then just north of it was the bleachery.
Okay. And would you indicate where the machine shop area was, if there was one?
It's on the east side of the building.
Over here?
Point to the furthest wall. Yes, sir. It was in that area on the basement floor.
So when you visited this facility on July 29 of this year, correct?
Yes.
On direct, on cross-examination, there was a question about the machine shop.
Yes.
And your answer was you didn't think the machine shop facility was there.
I don't think all of the machine shop equipment was. I saw part storage while I was there. There may have been one drill press, a small one.
You were referring to whether the machine shop machinery that used to be there.
Yeah, it is not there.
Okay, thank you. Now, when we were speaking about this building, let me show you the next photograph here, which is a February 8, 2017 photograph. And would you describe that building on the right?
That is the weave plant addition that Springs Industries constructed.
And is that the facility that you personally worked on the construction of?
Yes.
Design of? Now, would you tell me where, now if we go to February 24th, 2019, I'd like to point out to you that the roofing area up here, which you said was the bleachery before, is now kind of a bright white color, 2019.
Yes,
Can you
sir.
explain the difference there?
Well, the bleachery roof is a membrane that could be mechanically fastened. It may not be. I don't know, but I know that it was a rubber roof and was not a roof similar to the one just below it.
So, when we had the discussion of the roof replacement, how much of the roof of this building has been replaced?
The bleachery is all.
This white area here?
Yes, sir.
Okay. So, when we talked about the new construction you saw coming out of the ground in July of this year, where was that located in relation to this new photo here?
It was in the west side of the weave building, right there. Yes, sir.
Right, this area here.
Yes.
Your testimony does not in any respect address this new activity here, does it?
Only that underground fire protection piping was relocated for that purpose.
Yes. Now, in your review of the building in July, did you see this area to the south here?
The freezer building?
Yes.
Yes, sir.
That is, you understand that to be the freezer building?
Yes, sir.
You understand that to be an addition that Nestle Farina made?
Yes.
And you can see the difference here comparing September to February.
Yes, sir.
And here, this white over here, is that also another addition that Nestle Farina made?
Yes.
Can you identify any other additions to the building that you knew that they made?
No, sir.
I have kind of a brief question about the point that questions were asked about whether you reviewed all the documents at all. And I think in your direct testimony, you testified that you reviewed materials from Georgia Power Company files, including some Nestle Farina materials. But then I think, did you not mention also that you reviewed some additional materials transmitted by Nestle Farina, correct?
I have.
Yes. Do you recall specifically receiving a large hard drive from the Brian K. law firm?
Yes, sir.
Did you review what was in that hard drive?
I reviewed every document.
Now, you were asked some questions about the food safe environment, and when you, on July 29th, did you walk inside these buildings?
I did.
Were you accompanied by somebody from Nestle Farina?
I was.
Was that person Rachel, that now you know is Rachel Miller?
Yes, yes.
And didn't she describe some of the steps they were taking to you when you walked through the weed building?
She described one element,
Yes.
which was sealing of joints between the wall and concrete, of which we already had sealers in there, but it wasn't pet safe sealants. And so they used a coating to coat that and seal it to prevent pests, rodents from entering the building through those cracks. And that was observed everywhere we walked on the exterior of the building.
When you were asked a question about significant improvements for food safety from regardless of how significant that might be from a standpoint of food safety, is that a significant change to this building?
Oh, absolutely not. I mean, we put down a coating very similar when we built the building, and so did Lockwood Green. It was bituminous, or this is more food safety.
You showed a photograph from Mr. Martino's testimony showing a big area where there was a lot of dirt and pipes, and you said you couldn't be sure exactly where that was.
That's correct.
When you were walking this building, did anyone indicate to you a large area where flooring was replaced in order to replace with thicker, heavier flooring?
No. And the thicker concrete, we had about 7 inches there. You've got to really have some significant loads, but at the same time, your soil can only take so much. And so if they put thicker concrete down, I don't know what it is or how thick it was.
And did they indicate some larger areas where flooring was replaced, was changed out with the drain?
I saw one area, and that was in what we call probably the slashing area, and slashing and storage of weaving loom beams.
Mr. Lawson, go back to this bleachery for a moment. You had a question about the bleachery backs having been filled with something, correct?
Yes.
Now, did you see that they had demolished the bleachery area of the building?
That they had what?
Demolished the bleachery area of the building?
No, it's still there. You can still put a bleaching machine in. It's very easy.
So when you spoke about something being demolished, you were referencing that, the utility of the back?
Just the pits in the floor, and those were there to collect fabric as they went through the bleaching machine.
Mr. Lawson, we've been talking a lot about these types of mechanical things. And I'd like to ask you about how these different subjects that you were asked about relate to the integrity of the building and to its structure and functionality. And for example, does lighting replacement really make a change to the building or its functionality?
No. If someone told me what the foot candles were installed by Nestle Purina, I'd compare that with what we did for weaving, but no, I don't see anything significant there.
Does the replacement of heating, ventilation, and air conditioning really make a big difference in terms of who could use this building in the future?
No. The only thing that one would question is we used air washers instead of closed systems. We used open chill water systems. And it takes out a lot of airborne debris. I don't know how safe that would be for food safety. But certainly any other manufacturer can easily use the same equipment and would probably do so.
And when you're looking at the specific electric power for the air compressor building or for the weave plant area, the changes in that configuration necessarily restrict who could use the building now in the future for manufacturing or, in the case of this area, distribution, warehousing?
Absolutely not.
Changing out of the bleachery roof have any real impact on other people being able to use it for textile or other manufacturing applications?
It depends. If they didn't put a vapor barrier down, then somebody could get in trouble with it. But basically the answer is no.
terms of installing a floor drain, you know, how many thousands of square feet is that utility of it for textile or other manufacturing?
No, I mean, we close up floor drains every day.
When you've already testified this, but when you fill up a duct inlet, does that really affect future manufacturers or different manufacturers using it?
Not at all.
Um,
Very briefly, Your Honor.
I mean, really, really.
You're the boss.
Uh-huh.
You're the boss.
Mr. Lawson, Mr. Edwards directed your attention to the new cooler freezer building down here, did he not?
Yes, sir.
That's not a building that would be necessary for textile manufacturing.
It is for sutures.
But
And
were-
sutures
were
is part of
sutures being-
textile.
were Sutures being made at the spring factory?
No, sir.
Okay. So that was not part of the spring factory?
No, sir.
And we were in the cooler freezer that was active at the time, is that correct?
Yes. I wouldn't call it a freezer.
So
Temperatures were not freezing.
there were two separate parts of it, correct?
We went through both of them.
And one is designed to cool and the other is designed to freeze the fluids, is correct?
At the time that we were there was no freezing going on.
And you were told that that would be,
No, sir, I was not. I was just told this is the freezer cooler building.
so you don't know.
I don't know.
And with respect to the coving, which is the ceiling for food safe purposes, you said that was present around the entire exterior of the building?
From what I know it was in the weave plant, I know it was in the distribution facility. I didn't walk the wall on the cut and sew area, but I assumed that they did the same thing there.
And that was done for food safety purposes, is that correct?
I was told it was for food safety purposes.
It's not the type of ceiling that's necessary for textile manufacturing, correct?
No, sir.
I don't have anything further.
Thank you, Mr.
Lawson.
Excuse me?
Thank you, Mr. Lawson.
Thank you, Mr. Lawson. You can,
Thank you.
you got somewhere else?
May Mr. Lawson be excused?
Yes. In the meantime, I'll see if I can get this sound system fixed over the next, we have so many witnesses to go through. I kind of say, I guess, 45 minutes. Is that enough? Okay. So I'll see you back here. We'll recess until 12:45. Thank you.
Thank you.